said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
And Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life. I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she said it.
No,
No,
she didn't.
that's not true.
She asked a question.
It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck.
We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle.
Yeah, LTL true crime. We going deep in the dark. Yeah, peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie. Getting into minds of the wicked, no alibi. LTL true crime, unraveling the web of evil. No stone left unturned, we dive into the prime. Yeah, we digging up the dirt, bringing justice to the crime. LTL true crime, unveiling dark realities every time. Yeah, LTL true crime, we going deep in the dark. Peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie. Getting into minds of the wicked, no alibi. LTL true crime, go. We don't get living the show, but then I'm not talking about it, that's so. People go pushing your phone. No punctuation lie. No punctuation law. We better it done. You'll be without it, die. I don't know what it about. I think they'll true crime. You know what dark realities every time. This is I think they'll true crime. You know what dark realities every time. Yeah, LTL true crime. We going deep in the dark. Yeah, peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie. Getting into minds of the wicked, no alibi. LTL true crime. We going deep in the dark. Yeah, peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie. Getting into minds of the wicked, no alibi.
Well, Tom, I think we drew a crowd.
I can't keep up with the chat. It's just boom, page.
Well, we got something, and I wouldn't say something, but we have 8 somethings that we're gonna read through tonight. And I had a source slipped into me just a little while ago. It got a little hectic and frantic, and that's what was taking me so long. So I apologize. And we had the celebration stream just before this. So I'm not going to talk too much longer because everybody's going to go, get to the fucking letters.
Good. Can I talk real quick?
Yeah, absolutely.
Congratulations on the 15,000. And what you just did for your people is like not too many people do that. So that's appreciative. And there's again, the chat was cranking so fast I couldn't even read it. So you're doing the right thing, bud. You're doing great. Dude, real good job.
Well, we all are. It's a community effort.
Can we just get to the letters?
Yeah, fuck yeah. We can get to the letters. No, you know what? No, I'm sitting here. You know what? Stream's over. Goodbye. All right. Let's pull them up. We're going to go through them. So the first one's going to be 5'9". You're going to have to deal with my horrible reading. All right. Everybody excited? Sit back, kids, because we got a lot of reading to do. A
This
little
is
bit.
gonna get like dicey, boys and girls.
It's gonna get interesting,
Waiting
as
for
you
this.
say.
Now, what's the date?
Okay,
May 9th.
May 9th.
All right.
You want to read, Tom? Or you want me to read?
All up to everyone.
How about we alternate? We're not
Okay.
alternate.
You want me to do this one?
Do this one.
All right. Dear First Assistant Levy, I write to follow up on our conversations regarding the issuance of a federal grand jury subpoenas of at least 2 witnesses to the Commonwealth's investigation into the death of John O'Keefe. As you know, indictments have issued in Norfolk Superior Court, and the prosecution is ongoing. See Commonwealth versus Karen Reed, number blah, blah, blah. As prosecuting agency at the Norfolk District Attorney's Office, has the constitutional duty to provide the defendant with exculpatory evidence. The obligation in Massachusetts to provide exculpatory information pursuant to Brady versus Maryland and its prodigy means not only the constitutional obligation to disclose exculpatory information, but also the broad obligation under the rules to disclose any facts that would tend to exculpate the defendant or tend to diminish his or her culpability. Yeah. In the matter of grand jury investigation 495 Mass under Massachusetts Rules of Criminal Procedure, mandatory discovery includes all facts of exculpatory nature in all statements of witnesses. See Mass Crim, page 14, chapter section.
Right.
To effectuate
Yep.
our discovery obligations, we are requesting at the earliest possible opportunity discovery of all statements of witnesses to the investigation into the death of John O'Keefe and resulting prosecution, including both statements to investigators and grand jury minutes. The Commonwealth also has the duty, at the time we became aware that statements of witnesses exists, to notify the defendant under items under Rule 14 that the prosecutor knows to exist, but are not within the care, custody, or control of the prosecution, and to provide all information known as to the item's location and identity of the persons possessing that item.
Hang on one second. I'm just going to address this. Here's the thing, okay? I'm not a legal scholar. Tom's not a legal scholar. There's going to be some things in here and there's going to be language in here that I'm going to struggle with or whatever, okay? Tom's doing a fantastic job. We're doing this because these were provided by a source, and everybody should be celebrating here that we're doing this tonight. So honestly, if you're going to be rude, just go wait. You can read them when they get posted. You know, I don't want to hear stuff like that. Tom's doing a great job. I wanted Tom on the stream with us, and we're going to hang out and do this tonight. This actually wasn't the stream we had planned, but this popped up at the last minute. And I said, guess what, Tom? I got something.
And I've never read this before. It's the first time.
We haven't read these yet. So we're reading them blind here. So you're going to have to deal with us.
And
you want to wait till I read? It's going to be.
I'm trying to process this in my head at the same time. I'm going,
Right.
oh my God. Oh my God.
Well,
Like,
deal with us.
15, we know this. And there's a lot of $5 words in here.
We're going to get rid of it. I mean, we're going to get through it. It's going to take us a little while here. So.
I need like these words, like I need $3 words. I can do those. The $5 ones are like, oh my goodness.
Okay.
You want to go from here. You go from here.
Sure. It looks like it's citing a law, Commonwealth versus Mitchell. We appreciate, and again, I'm going to post these all up on my Twitter after this, so everybody can get these. We appreciate the sensitivity and all of the discretion as to ongoing federal investigation. While we're aware of the perimeters, the federal activity, we cannot forgo our constitutional or state duties. We're willing to file a motion for the protective order under the Mass criminal law to require limitations of the disclosure for information to the defense counsel. Only any decision of such request is coarse and solely within the authority of the Norfolk Superior Court. Similarities are willing to facilitate the process. Order request under the federal, and this is the criminal law again, the authorization from the federal district judge of prosecution, production of the grand jury minutes and related material, if any. Additionally, if these officers have constitutional and state obligations to provide exculpatory information of which are aware in cases including exculpatory information relating to all witnesses and the members of the prosecution. Committee for Public Counsel Services versus Attorney General. So it's stating another case that had probably started this law, from what I understand. This would be any investigation into misconduct related professional duties. If such any information exists, it is imperative that we learn from this in a timely manner. In the sum, we appreciate the notification that the subpoena is issued. It is imperative that the earliest opportunity we're able to provide discovery to this defendant. Wow. And that was from Lynn, I think it's Bedlin or Beelin,
All right.
First Assistant District Attorney. Go ahead, Tom.
So this letter is who writing to who here? This is the
It was Levy. Was it Levy? Let's see.
Yeah, this was Josh Levy.
Yeah.
This was to Levy.
To Levy.
To Levy about the subpoenas and the grand jury and exculpatory evidence that wasn't provided in Rule 14, it seems, which is her right to be able to get exculpatory evidence that proves she is innocent, and they don't want to give it to them. It's right there. Is that what we read?
I'm not a lawyer, but that would be my layman's take on it. You know, I wish we had a lawyer. Melanie Little, are you here?
Where's Olivia? She's our go-to girl. I mean,
is Olivia in the chat? I can pull her up.
She probably wrote this. She probably made these words up.
But my point is, let's just get them out there. We're going to post them for everybody to look at afterwards. And, you know, we can go from there. Okay.
Nice.
Let's go to the next one. So this here is coming from the Department of Justice. This is on May 18th, 2023. Let's see. Investigation.
This is from Morrissey.
Morrissey.
So this is Morrissey's response to that letter. Okay.
To that letter.
Here we go.
Dear Sir or Madam, I'm right to formally, I think this one had been out already. I think I've seen this one. To write and formally request an ongoing investigation being conducted by the United States Attorney's Office for the District of Massachusetts by examining the Office of Professional Responsibility, and should be investigation continued to be transferred to another office without history or conflict, bias, abuse of prosecutorial discretion as outlined below. The Norfolk District Attorney's Office has been undertaking an extensive investigation into the facts and circumstances of the death of John O'Keefe in Canton, Massachusetts on January 29, 2022. You know what bothers me about this? I don't think I've seen once in any of these letters of looking, it doesn't even say, he hasn't even said officer yet. He says it in the second sentence, the next paragraph, but he doesn't even say Officer John O'Keefe, which I think should be there out of respect.
You would think.
Go ahead, Tom.
I mean, you would think he's a police officer, and granted, he wasn't, hurt in the line of duty, but granted, you're always on duty.
So the facts of the evidence gathered include more than 40 individuals testifying before the Norfolk County Grand Jury led to the second-degree murder indictment of Karen Reed. Reed was an operator of a vehicle that the evidence demonstrates. Sorry, I had to laugh.
I'm glad he wrote that.
The evidence demonstrates struck by her boyfriend, police officer John O'Keefe. John O'Keefe was then left to die in the snow on the side of Fairview Road, Canton, during an evening of January 29, 2022. The case has been systematically making its way through Norfolk Superior Court with ongoing discovery still active and open, including motions under advisement and motions not yet heard. The defendant, through counsel, has been raising suspicious issues of a third-party culprit and complaints of witnesses and police misconduct as they attempt to confuse by offering not different interpretations of the Commonwealth statements, evidence, and positions, but inventing them out of whole cloth. Holy shit. No actual substance evidence supporting police misconduct or any federal violations have been identified by the defendant, the district attorney's office, or the Massachusetts Superior Court during the ongoing discovery process. See Exhibit A, defendant's filing of the Commonwealth's response. Approximately 3 weeks ago, multiple state witnesses who had brought before the state grand jury notified the Norfolk District Attorney's Office that they are contacted by the FBI and subsequently received subpoenas to appear before a federal grand jury. Shortly after those notifications to the Norfolk District Attorney's Office, Joshua Levy, first assistant in Boston office of the United States Attorney's Office, contacted Norfolk first assistant district attorney Lynn, is it Beelin or Bedlin? Beelin, to suggest that they have conducted the investigation that may involve a number of witnesses in the Commonwealth versus Reed murder case. At that time, Attorney Beelin expressed some concerns about both the jurisdiction and the timing of the actions being taken by the United States Attorney's Office, as they could imprudently impact the ongoing murder prosecution of Karen Reed. Based on the collective experience of several of my colleagues, Massachusetts District Attorney and former federal prosecutor, it appears that unprecedented for the federal government to step in the middle of an ongoing murder prosecution prompted by only inflammatory and ethically dubious defense strategies. Holy shit, man.
Talk about calling him a liar. Wow. Woohoo.
In the conversation with the first assistant Norfolk District Attorney, Lynn Beelin, Assistant United States Attorney Joshua Levy declined to identify what jurisdiction the federal government had in its murder case. It appears to be highly unusual and possible abuse of excessive power. Attorney Levy indicated, sorry, my mouth's getting dry, indicated that the U.S. Attorney's Office is still proceeding ahead with an investigation that would involve individuals who have active participant in events and or witnesses in the state's case. Attorney Beelin reminded AUSA Joshua Levy that any statements and ongoing testimony taken in such an investigation that pertains to any of the witnesses in the ongoing state murder trial may create an ongoing obligation for the state's prosecutors to provide defense with access on all information and statements gathered or recorded as a result of the federal investigation. The United States Attorney's Office offered the opinion that you can't turn over information you don't have. This position leaves state authorities potentially unable to meet the Constitution mandate expressed in Brady versus Maryland and the corresponding Massachusetts state rules. Excuse me, I need to get a sip of water. Since that call concluded, we have confirmed that the witnesses have testified before the grand jury. Rule 6 of the federal rules of the criminal procedure allows, allows that under a certain compelling circumstances, information may be provided to all counsel, including those not before the federal grand jury. See Exhibit B, letter. Recent court filings and statements by the defense counsel in the Reed matter suggest that the defense attorneys were the source of the initial complaint and allegations prompted this action by the U.S. Attorney's Office. See Exhibit C, report in Boston Herald. Reed's defense counsel recent court filing raised out of thin air apparently proposed misstatements of facts, unsupported claims of a cover-up by the investigators and witnesses, including municipal, state, and federal law enforcements. As shown in the attached document, many of our unsupported allegations may be vetted and reviewed by the judges in Massachusetts Superior Court during the discovery motion sessions or available appellate review. I am unaware and strongly doubt any prosecutor of the state police misconduct in Commonwealth versus Karen Reed. The only allegations to that effect may have been unsupported new claims or defense filings, excuse me, that have not been unanswered at times. Levy confirms the existence of the federal grand jury. It raises questions why the apparatus of the DOJ would intervene, even as such issues are still being assessed by the Justice of the Massachusetts Superior Court without some additional impedance on the part of the United States Attorney's Office. Without dismissing the important role of the DOJ in the investigation allegations, police misconduct, and federal violations, we bring to your attention what appears to be additional concerns concerning motive, conflict, or appearance of conflict and potential bias of the Office of the U.S. Attorney of Massachusetts, which may explain these unprecedented proceedings. I predicate the following information, the facts that have been the policy of the Norfolk District Attorney's Office during my 12-year tenure as DA, to maintain a close working relationship with the United States Attorney for Massachusetts. Notable in that relationship, under the cooperation of the Norfolk DA's office in the prosecution of a 35-year-old murder case committed in Sharon, Mass., which involved Whitey Bulge's gang in the United States versus Fleming.
Funny he brings that up.
Right? Excuse me 1 second. The Norfolk DA's office had statutory jurisdiction to pursue the case, but in the interest of cooperation, acceded to request of the United States Attorney at the time of allowing the federal prosecutors to proceed with the case. As a result of the agreement, the Norfolk DA's office and Massachusetts State Police assigned to Norfolk DA's office worked closely with the U.S. Attorney's Office on the case during the period. Dustin Chow, without nexus to the prosecution, asked Massachusetts State Police detective involved in the matter if he had any kind of damage information on the district attorney, first assistant, or the Norfolk DA's office. This SUA, I don't know what that is. Sua Sponte question, I don't know if that's right, was not without context. Laura G. Chow, Dustin's wife, had been an employee of the Norfolk DA's office prior to the case mentioned above. Not long into her tenure, it became apparent to her supervisors that she required more seasoning and legal experience if she was to succeed in a superior court role. She offered the chance to gain more trial experience in the district court without any loss of compensation. Instead, she resigned and filed the ethics violations complaint with the Mass Board of Bar overseas against the first assistant in the Norfolk District Attorney's Office. The complaint before the board similarly dismissed in short order. Laura G. Chow was cited for violations of her ethical obligations to provide accurate address information in her practice. Long before separation, she was misrepresenting her address as Norfolk DA's office. See Exhibit D. I begin composing this letter well before May 17, 2023, publication of the DOJ's Office of the General Inspector Report 23-071, which apparently prompted to resign of the current U.S. Attorney of District Massachusetts. My attention is drawn to several portions of Section 2, particularly as they pertain to the weaponizing the U.S. Attorney's Office for personal and political retributive purposes. Page 46, Hayden will regret the day he did this to you. Watch. Page 66, we asked Rollins whether to disclosure or or retribution for the wrongs she believed Hayden had committed. Additionally, we determined that the days of Hayden prevail in the September 6th primary election. Rollins sought to damage Hayden's reputation. The evidence demonstrated she used was portions of the U.S. attorney and ultimately unsuccessful efforts to create the impression of publicly that the DOJ would not be investigating Hayden for public corruption. These DOJ findings and questions reinforce my belief that the U.S. Attorney's Office for the District of Massachusetts must be removed from whether the investigation is being conducted into Reed's matter. I believe that a responsible person could conclude that the same type of tactics are being employed against the Norfolk's DA's office in the Reed investigation. The ongoing U.S. attorneys has made no secret of their personal animosity towards me, including repeated crude and outlandish personal or professional attacks against me in the media. Oh, I don't know why I just had to do that, but I did. During her time as the Suffolk District Attorney, the head of the Public Corruption Unit has raised a specter of personal retaliation for his wife, departure of the Norfolk Attorney's Office. The public has the right to the Attorney's Office that is fair and unbiased as it executes its responsibilities.
Wow.
Weaponizing, what's that, Tom?
The public has a right to a U.S. Attorney's Office that is fair and unbiased as it executes its responsibilities. Ain't that the truth?
Can you read the rest for me? I need a break. Where I'm weaponizing.
Let me just make it bigger. Yeah, there we go. Weaponizing the United States Attorney's Office to conduct an unprecedented intervention into an open state murder case appears to raise the same concerns outlined in the DOJ's report. I submit that the pattern of using USAO for personal purpose establishes in Report 2371, coupled with the obvious conflict of AUSA Chow, make it impossible to conclude that a fair evaluation of the unprecedented Reed intervention can be conducted by any party within the Massachusetts office. It is impossible to determine how far the tentacles of bias have spread out from the chief of the relevant unit of the titular head of the office. What's that word?
Titular.
Yeah. Man, what's with these $10 words? I formally request that an impartial federal official unaffiliated with the U.S. Attorney's Office for Massachusetts review and investigate the steps and actions that are being taken by current members of the Massachusetts office, exploring this apparent bias and whether it predisposed them to abuse their prosecutorial discretion in this matter. In the unlikely case that an impartial review finds that DOJ investigation into the Karen Reed matter is appropriate, even before the issue at hand have been vetted by the Norfolk Superior Court judge in this case, I request that the investigation be reassigned from parties with clearly stated and documented bias against members of the Norfolk County District Attorney's Office attorney entirely outside the office of the United States Attorney. So he's asking them to take this case and move it out of Massachusetts from the people who have a bias against the DA to someone who doesn't have a bias against the DA. Right? Is that what they're saying? And Laura Chow, they're saying that Laura Chow, right? Because she worked there at one time and she didn't get what? Promoted? That she's saying it's sour grapes? Is that that's what he's saying? Gonna blame this poor lady?
Pretty much.
Laura Chow? And there's 40 people? There's 40 individuals I got like 12. We need to find them other numbers. Where is everybody? 40 different people. We're missing people here, guy.
All right.
So this is got to be the response. So that was Morrissey's response to the feds, and the federal. This is the federal back to
writing back.
Don't blame your past employee, maybe.
Yeah. So the DOJ now writes back to Morrissey. This is June 1st, 2023. So it goes on to say, Dear Mr. Morrissey, the official and professional responsibility OPR received your May 18, 2023 letter requesting that the OPR investigation decision by the United States Attorney's Office for District of Massachusetts to subpoena the individuals who are witnesses in your pending state prosecution, Commonwealth versus Reed, is the case number, to testify before the grand jury in the ongoing federal investigation. You stated that the USAO's investigation is possibly an abusive excess of power and likely based only on defendant Karen Reed's suspicious claims of witness and police misconduct. In addition to the investigation of the USAO's investigative decision, you've requested that the OPR transfer, excuse me, the USAO's pending investigation to another office without a history of conflict, bias, and abuse of prosecutorial discretion. The OPR and jurisdiction in the investigation allegations misconduct involving Department of Justice attorney that relate to the to the authority of the investigation, litigate or provide legal advice, as well as the allegations of misconduct and the law enforcement personnel that relate to the allegations of the attorney misconduct. Sorry, I just lost my spot. Where the hell was I? Relate to the allegation of the attorney misconduct within the jurisdiction of the OPR. However, it is the policy of the office to refrain from investigating such issues or allegations if the active investigation is ongoing or litigation is pending. Goes on to say, with the request that the other office can be assigned to the pending grand jury investigation, a matter outside the OPR jurisdiction or OPR, forward your complaint to the Executive Office for the United States Attorneys for whether action deemed appropriate. Further inquiry regarding the issue may be directed to EOUSA General Counsel Jay Macklin at, and then there's the address. Thank you for your advisory, OPR, and your concerns. Jeffrey R. Ragsdale, Counsel. And it went to Macklin as well, too.
So Morrissey read that letter right there before he made the statement. So he knows that, hey, we're coming for you. We don't want to hear all your nonsense. This is happening.
All right, here we go. So this is from Levy to Bedlin. So you got Levy to Bedlin. So it says, First District Assistant Bedlin, thank you for your letter dated May 9th, 2023. My apologies for the delay in responding, but I have been tied up with transition issues. We understand your office has important discovery obligations in a criminal proceeding. At this juncture, we have no issue with you advising defense counsel about the contact we have had with your office and the information we have shared if you determine such a disclosure is warranted under Mass R Criminal 14. We are mindful of the important concerns raised to your letters and will be back in touch with you as circumstance dictates. And that was from Levy. Or Levy, I'm sorry. I always say Levy. It's Levy. So that was on June 12th.
So that's them saying,
okay,
thanks for responding, but it don't matter.
Right. Now we go to the 21st.
That's quick.
Morrissey.
The first, right? This is
so you went from
quick
from the 1st to the 12th. Now we're at the 21st. This is Morrissey. Again, dear General Counsel Macklin, this letter is to inquire about the status of a request for a transfer of the investigation due to a conflict of interest. On May 18th, 2023, the Office of the Norfolk DA's sent to the Department of Justice of Professional Responsibility a letter raising concerns as a potential investigation by the United States Attorney's Office for the District of Massachusetts involving witness relating to the pending criminal matter Commonwealth versus Karen Reed and the death of John O'Keefe in Canton, Massachusetts on January 29, 2022. This office has subsequently received a June 1st, 2023 letter from Jeffrey R. Ragsdale, counsel for OPR, reflecting that the extent of the letter indicated that the pending grand jury investigation should be reassigned the appropriate office to the address that requested the Executive Office for the United States Attorneys. This is to inquire about the status of this request and to provide contact information for any further information you require. If you have any questions looking for any additional information, I may request contact as set out. Sincerely, Lynn Beelin.
The request. So they're saying they're asking, hey, what's up with transfer of this case? That's what they're asking in this letter.
Essentially, what's
Right.
going on? Right.
What's going on? What's happening with it? It's going to get moved. We're keeping it here.
Right.
Nice.
All right. We're going to go to August 3rd. This one, I think, was the most interesting one that I heard of. So the Department of Justice writes back to Bedlin and says, this response is to your June 21st, 2023 letter concerning your punitive request for recusal of the United States Attorney's Office for the District of Massachusetts from the pending state criminal matter Commonwealth versus Reed. As you indicate, the Department of Justice or professional responsibility informed you that they have referred to your May 18th letter to my office for whether action I deem appropriate. Consulate with the terms of the referral from OPR, I contacted Acting U.S. Attorney Joshua Levy. Based on my understanding from that discussion with U.S. Levy, his office has very different opinion of the circumstances in this case than as presented by Mr. Morrissey's letter. His office was not reached at any official determination whether prosecution is warranted. Whether prosecution is warranted. But they believe it is essential to continue their investigation, given the information of which they are aware. At this time, we see no bias for recusal in the investigation. Thank you for the contact information, willingness to provide additional information as needed. And that was Macklin.
I like that. It says there, letter to my office for whatever action I deem appropriate.
Right.
Telling Mrs. Beelan that, thanks for your letter, but we're going to do what we want and do what we deem is appropriate. That's good. And that must have been the reason he stroked out and said that. What was it, 23rd? Yeah, August 25th. Morrissey come out and started yelling at everybody. And
yep.
Remember that? The 25th.
Yep. He had that little meeting.
He had this in his hand.
He knew this. He had this in his hand.
He knew this.
That's what prompted that meeting, that televised thing from Morrissey. That's why he came out and did that, to get it out in public relations bullshit out there.
Yeah.
All right, let's go to October 12th. This is Morrissey to Levy. Dear First Assistant Levy, this is the follow-up on a previous communication dated May 9, 2023, and your June 12, 2023 response. On September 15, 2023, the Norfolk Superior Court set a trial date of March 12th, 2024. There's your trial date, yeah. 2024 in the Commonwealth versus Reed. Case number on the indictments for the second-degree murder, manslaughter, and operating under the influence and leaving the scene of personal injury and death. Bullshit. Lies.
I know, huh?
Under the Massachusetts Rules of Criminal Procedure, the mandatory discovery includes items of information with the Commonwealth's possession, custody, or control relevant to the case, including statements by the defendant, Karen Reed, statements of persons who testify before a grand jury and a grand jury minutes. In fact, the exculpatory manner, manner, materials and relevant police reports, photographs, tangible objects, reports of physical examinations of any person in scientific testing experiments, and statements, persons intending to be called as witnesses, and disclosure of promises rewarding or inducements made by witnesses of the parties intends to present at trial. We have the criminal Rule 14 there. The Commonwealth also has a duty to notify the defendant of the items under Rule 14 that are known to exist that are not within its care, custody, control, or provide the information known as to the item's location and the identity of the persons possessing the items. To effectuate our discovery obligations, we are requesting a statement to investigate any and the grand jury minutes of the witnesses in your investigation as well, to the extent that may exist. Goes on to say, any of those above described items or materials, given the impending trial date, prompt disclosure is critically important. If there is any need for limit disclosure of such items, please include such a request. We are willing, with the appropriate foundation, to file a motion for protective order under Mass Criminal Rule 14 to request limitation of disclosure for the information of the defense counsel only. Any discussion of such request, of course, is solely within the authority of the Norfolk Superior Court judge. Similarly, we are willing to facilitate the process or request under Federal Criminal P for authorization, for the Federal District Court judge for production of the grand jury minutes and related materials, if any, and discuss per that rule under the conditions of the material may be released for us to use the state judicial proceedings. Additionally, this office has a constitutional and state obligation to provide exculpatory information for which you are aware in this case, including exculpatory information relating to all witnesses and members of the prosecution. This would include all investigation and misconduct related professional duties. If any such information exists, it is imperative that we must learn in a timely manner. It is imperative that all earliest opportunities they were able to provide discovery to the defendant. If the investigation remains ongoing, we will require notice of the status of the information, as then when the investigation may conclude, in particular whether the investigation is anticipated to conclude prior to March 24th trial date. And that was from Bedlin.
Can I say something?
Sure.
Kellen Wanders, quote, don't read legal documents incorrectly. It's embarrassing. Making up words, skipping words. This is a terrible reading job. All your Cash App links clearly show you're chasing the dollar, not truth. Well, Kellen, please come on here and you read for us. You read for the class, and let's see your reading comprehension skills in front of everybody.
I'll drop the link to you anytime.
That is so Morrissey. Like, let's talk about the word that we've pronounced wrong, not the fact that he's got the letter in his hands. We're not going to talk about that. Let's talk about how I don't know a word. Bullshit. Beat it.
So, this is the thing, Tom, with people like this, okay? And I was talking about this the other day, and I don't want to get too hung up on this because I want to get to the last letter that's very important. These are people that are very angry with themselves because they never accomplished anything in life. So, I always say this: if you hate what we're doing, start your own channel. Start your own channel and talk in the reverse. If you think that Karen Reed is guilty, then start your own channel and talk about it. I don't go on to these other channels. I don't go into other people's chats that have Karen Reed as guilty streams. I think we've stated our position here. We have a very tremendous, strong outreach and a very strong movement here. We want to know what's going on in this case. And I don't think there's anything wrong with what we're doing. See, the problem is that people are very upset because the onion layers are getting peeled back now.
Yep.
You know the old saying in The Wizard of Oz, Tom? What does the wizard say? What does the wizard say when they're all standing there and they go to see the wizard?
Attention to the man behind
the curtain. And guess what's happened in this case? Turtle Boy went over and started to peel that curtain back and draw it back really slow and expose what is going on in this investigation.
Yep.
So
this is incredible. I mean, and part of the problem is I'm trying to read and comprehend, like, oh my God, like it's that onion layer. I'm trying to look at all the layers as they're getting cut away. It's crazy. We shouldn't be reading this.
Yeah. Well, I'm going to post them in about 5 minutes anyway. So if you want to go and fucking read them for yourself, have a nice day.
Boom.
All right, let's get over to the last one here.
And this is when?
This is November 22nd, 2000. So very recent, last couple months. So we got Michael Morrissey. Let's see. November 22nd, 2023. Dear SAC Cohen, it is a pleasure to meet you at the State House for the governor's press conference on hate crime enforcement. I wanted to again extend my welcome and best wishes to you in your role of Boston Special Agent in charge of looking forward and working with you in the future. I also wanted to renew this office's offer for your agent to speak with state police who were involved in the John O'Keefe Canton murder investigation. My first assistant district attorney also mentioned our willingness to talk to the FBI, to the acting U.S. attorney in a recent phone conversation. If you would like to have this in your investigation, they can contact us here at Tully. And here is Michael Morrissey writing back.
So he's given up Tully. Here, you're going to send you Tully to make it all right. He's going to answer all the questions.
Mm-hmm.
They had a meeting at the State House for the governor's conference. Nice little conversation they had.
Mm-hmm.
That last letter is what that's interesting. I want to read that one again.
You want me to pull it up again?
Yeah, can you?
Yep.
It was a pleasure to meet you at the State House for the conference.
Go ahead. You can read it.
I also wanted to renew this offer with your agents to speak. So the office offered the agents already a chance to speak, right?
Right. And now he's saying,
he's saying,
is this agent?
I want here.
Yeah.
You're bring me your agent, and
bring me your agent.
I'm going to give you the state police who were involved with it. Okay. So that letter is just like, hey, I don't want to say he's throwing Tully under the bus, but I mean, he's putting Tully out there. Tully's a go-to guy. I think he's going to be in a lot of trouble, I think, if this comes down.
Can we just do this real quick?
We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle.
I wonder if, like, the Chestnuts get letters like this in their case, right? The cop, the Weymouth cop that got murdered there.
Mm-hmm. Well, there's always conversation going on behind, what we know. There's always deeper conversations going on, and I think like we heard about a federal probe very early in this case.
Maybe halfway. Maybe halfway.
Yeah, like pretty early on.
Well,
I heard the rumor of a federal probe.
What halfway is halfway from when Aiden started reporting it, not from when it happened. I mean, from when it happened till now must be like, I can't imagine how forever that long that time must be for Karen.
Right.
That time's going to be forever time. For us, it's only been 8 months, and we're in the middle of it.
Right.
Wow.
All right, let me just do this really quick. I want to recognize, because I couldn't get to any of this while we were our horrible reading. I told everybody, listen, I'm going to tell you flat out right now, and I've quoted this a million times. I have a mild form of dyslexia and I have a stutter, so you're going to have to put up with me a little bit. I thought I actually read through pretty well.
I couldn't tell either one of them.
I don't read legal documents, but the most important thing is I got them on the screen so people can see them, and I'll post them up on my Twitter after if you all want to go just read them for yourself. Okay, let me just do this real quick. Thank you so much for the new Leona. Thank you so much for the new membership. Carrie Ann, thank you for the membership. I appreciate it. Jessica, thank you for the support. Heather, thank you for the support. Nancy, thank you for the support. Debbie, thank you for the support. Melissa became a new member. Thank you so much. Renee, thank you so much for the super sticker. I appreciate it. Amy in Boston, using her 1-month membership, says, we love you both. Don't worry about a thing. Hashtag just for John O'Keefe. Absolutely. I completely agree. Angela P, Brian and Tom, thanks for the info. You're doing great. Thank you so much for your super chat. I appreciate that. Kaz D became a member. Thank you. Carrie H with the $4.99. Brian and Tom, you're both doing a fantastic job reading to this. Thank you and we appreciate you both. I appreciate you being here. Thank you. Scott Dipson says, this is a big cry baby letter from Fat Cat Morrissey, and he's bitching and fishing for the U.S. Attorney's Office. Absolutely. Chirp 199 says, rip Steven DeSaro, Sharon murder mentioned. Yeah, absolutely. Nicey, thank you so much for the $9.99. I'm going to use them in the terms of $10 words. Carrie H again with the 10. She's doing an amazing job presenting the letters. This is mind blowing. Thank you, Carrie. You guys are doing great. Thanks for everything. Thanks for the 10. Carrie just gifted 10 memberships. Welcome new members. I appreciate it. Mr. Mark says, thank you for this. You guys are both doing better than I could. Please don't listen to the haters. Yeah, listen, it is what it is. It's part of what we do, and it's shit we put up with, but this is important. Super, super important. And then a big $50 super chat. Thank you, Michael. Appreciate that. Read to us, Brian and Tom. You guys are the best. Thank you.
Nice car.
Very nice car.
66. Is that a 66? I'm wondering, maybe. And
probably that era.
Is that a 383 or a 440? I asked.
He'll probably let us know in the chat. So yeah, I mean, the thing here again, I'm not a legal expert. I have to really go through these again to really understand, but it's a lot of back and forth. Looks like Morrissey's fishing for a lot of information. Like, hey, you guys gonna be investigating this or what's going on? That's what I'm trying to get at.
Remember, he asked them, "Don't worry about it. Can you go away?" And
yeah, essentially.
And they're saying, "No, we're not going away."
Yeah,
that's an awesome. Yeah. I mean, in the next couple of days, it's going to be nice to see the fallout from this, because it takes a day for it to get out there, a day for people to actually absorb it, and then look out, and then this will come out, and then this will come out, and it's things that we don't even notice right now. Right. In the same letters. Give them to Olivia. Come back in 4 hours, and we'll have she'll have 8 different things to talk about that we can't even see at the moment. Just because it's right in front of us. Yeah, I think Josh has.
Play the press conference from more. Remember I'll get the Morrissey press conference. Let's play that now that we know what.
You can see the anger now because he asked them to stop investigating this, and they said no. And now
see this.
Come out with the letter.
I want to see what he's.
I wonder if I'm sorry, not the letter, the statement. I wonder if he did that to double down on the Fed saying
that's probably it. Yeah, it's basically it's all right. He's
looking for nothing.
It's all right. Yeah,
it's exactly what he did.
All right, let's play this because I want to remember this.
This will be the first statement of its kind
I use the bathroom.
in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative.
He said that twice. Stop.
Colin Albert didn't commit murder.
Go ahead.
He said that twice. he just claimed that Colin wasn't in the house twice.
Well, why would you do that? Why would you try to put through the point like, no, that person wasn't there?
There was no fight. He never entered. Colin wasn't in the house.
Why would you do that, though, Tom? Why would you double down on that?
Twice. 2 times he said it in not even a minute.
Yeah, why? But why would, it's just like,
And don't get me wrong, I'm not hating on
people
Colin.
do. I listen.
It's just, I just noticed that the DA said that he was not in the house. He said that twice, and we've proven that he has been in the house, and he was there before Karen and John got there. So we know those are facts. He was inside the house before they got there. So Colin was at 34 Fairview at the party. He was there that night. They say he left.
I need to laugh. 8 letters, 8 chins. I like that. All right, let's go back to that. I want to rewind that.
But you see what I'm saying? He said twice that
Doubling
Colin
down.
was in the house.
Pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home.
That's
The
one.
phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that
What did he
18-year-old
say? Our phone information? Our phone information?
Testimony from witnesses tell us that 18-year-old John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all.
Phone evidence. Okay.
Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home.
So he's actually saying he was at the house, but he left before.
That's what he's saying. So Colin wasn't in the house? That's a lie. Colin was in the house.
That's
But
bullshit.
Morrissey twice is saying that.
Why would you say it double down on that twice to make that point?
Bingo.
Yeah. Because it's a cover-up.
O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority.
He just said Colin Albert again.
Imagine that.
That's 3 times.
4.
4 times. I missed one.
Providing statements and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
Yep, you're right. It does need to stop. And what's happening to these innocent people, it needs to stop. He's right. And I think Josh Levy's in our court and he says, yeah, you're right. It's going to stop.
Huh.
But it's funny. He's defending Colin more than Lally is. Right?
Very interesting. Now that we have the letters and we can see what's going on behind the scenes, and then that response. And I think, like you were saying, I think that's to get that out there to shake the feds. Okay, guys, it's okay. We got it. Just go away. And then the feds wrote back at the end and said, no, we will offer you one of our special agents. You should talk to him.
We'll do what we want.
Yeah.
Thank you.
And again, I'm sure Olivia is going to be all over this on Twitter tomorrow. If she was here, I would have brought her up. I want to just make a statement. I need to make a very, 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 very important statement. There are numbers and there are email addresses in those legal documents. These documents are public, but I don't want anybody calling or emailing any of that. You will get yourself in so much trouble. It's not even funny. So don't even go there.
If you're the person who's going to call those numbers and see who answers the phone, then don't be associated with this movement, because that's not who we're about. We're letting the feds take care of this. We're not going to railroad them. We're not going to go and blast their phones up.
Right. I don't want anybody calling. Olivia, if you want to jump up, I'm going to drop the link. I don't know if you're prepared to jump up, but if you want to jump up and there's anything interesting that you want to talk about here, we'd love for you to join. So I have the link if you want to jump up and I can bring them back up. She said, I can't call tonight. Sorry, maybe another time. No problem.
That's all right. It's
fine.
I'm sure, Olivia, what time you spend on this and what time you give us in your analysis of this is more.
And I'm going to email these to Melanie Little so she can go through them on her stream. So I'll get these over to her tonight and just say, hey, I have the 8 letters. If you want to read through them on stream, let me know and go for it. So I'm going to get those up.
Great to hear from also.
Yeah.
I mean, this is
I'm already going to tell you too. I'm sure Lawyer You Know is going to jump on this. I'm sure Melanie Little's going to jump on it 100%.
LTL. But no, what's the MLM making
Law Simple will probably jump on this.
Yep.
So there's going to be plenty of people, plenty of lawyers that will jump on this on their streams, and they'll be able to go over this. But we just wanted to get these out. Like I said, I had a source come forward and said, hey, I got the 8 letters if you want them. I said, absolutely. And they said, go ahead, drop them, do them, and it's fine. And I'm sure they're going to get they're already posted. I heard somewhere, someone in the chat said they were already posted. So, but I'll get them out on my Twitter. If you want to read through them, you're welcome to do that. And I'll post them up on my Facebook as well too. I don't know, Tom, any parting words before we get out of here?
I can't believe we're dealing with this right now. Like, can you believe that the feds gave us the letters that they've been given back and forth to Morrissey?
Right.
I mean, this is the guy who's in charge of the law enforcement in Norfolk County. Promised us Colin wasn't there, that John never went in the house, and that there's no improprieties in any way. He promised us that live on TV. We saw that, right? He told us everything's on the up and up, right? If I lived in Norfolk County, I would be beyond outraged.
Yeah. Oh, speaking of that, tomorrow I'm going to be doing the Canton community hearing. So I'll do that live on my channel starting at 7 o'clock. If you all want to come over and hang out, I'd love for you to be here. So we'll be here doing that. I'll stream that live. I don't know, Tom. Crazy stuff. Again, I'm not a legal expert, but it seems like a lot of back and forth and a lot of Morrissey trying to push away in these documents. So
thank God that Karen gets to read these letters. You know, maybe they'll get to Aiden. Maybe he'll get to read them, give him some really good news. But I mean, thank God Karen isn't in the dark. She's got some sort of hope with these letters. There's a hope. There's a glimmer. Otherwise, she's got this. These people are against her. All these corrupt people telling the FBI, "Nah, go away. We got this. No, don't go away, FBI." That's what she's fighting.
Yeah, this is big for Karen. It's big for this case. So, look, I appreciate everybody coming in here. We had a lot of people in the chat. I appreciate all the donations. I appreciate everybody hanging out on the celebration stream before that. And what a way to celebrate. This is a great way to celebrate. This is the cherry on the top.
Yep.
And tomorrow night we'll do the hearing tomorrow in Canton. And we'll go from there. We'll just keep fighting forward. Thursday, I will be with you at court on Thursday.
Can't wait for that.
At Aiden. So we'll be there. We'll be there Thursday in support. And I won't wear sweatpants this time.
We'll get Aiden taken care of next.
Yep. So
thank everybody for being here, for watching us, and congratulations on your show again.
Thanks.
You did was just awesome.
Thank you. Like I said, if anybody's in here, if they were prize winners, you need to get in touch with me within 24 hours. We'll get you vetted and then get all this stuff sent out. Hopefully this week or next week. It will definitely be in the mail. Listen, if anybody gets the opportunity, please smash the like button. I'd love to get 1,000 likes on this stream. That would be great. It was 1,000 people here. We got 720 likes. I'd really like to get to 1,000. And if you haven't subscribed, subscribe to the channel. I really would appreciate it. And, look, I'm not a legal scholar. Tom and I did the best to read through them. We just want to get the information out there. You can dissect. I'll drop these on my Twitter if you all want to read them, up on my Facebook page as well. And Tom, thanks again for doing this. Let me just get this out.
Thank you.
$20. Yeah, Snake Devil is the abuser. Interesting screen name. $19.99. Would love to have fun on here dissecting the letters piece by piece. You guys are doing great. Don't be stage fright. Appreciate the both of you. Much respect. Thank you. I appreciate it. Let's play the long intro as the outro tonight. Let's do that.
Like that.
Before they do that, I gotta just do this one more time.
We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle.
God, so good. So fucking good. All right. We're going to get out of here tomorrow. Canton meeting tomorrow. I'll be streaming that. And then I'll probably be doing something for Aiden's channel again this week if they ask me to. And Tommy and I will be down at the courthouse on Thursday to support Aiden. Hopefully we make some progress there. And, he's on his way out soon. But
maybe we can get him on a show when he gets out Thursday, right?
Absolutely.
Positive thoughts. Need prayers, people.
Positive thoughts. As of right now, all I know, it's a 9 a.m. court hearing, but it could change. So that's the news that I know at this point. All right, we're going to get out of here. We're going to play the long intro as the outro. Everybody have a great night. Thank you for coming into the stream. Fantastic stream. You guys are all great. Thank you for all that you've all done for this channel to keep bringing on the up and up. We'll have more soon. Everybody have a great night. Thank you.
So said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
And Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life. I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she said it.
No,
No,
she didn't.
that's not true.
She asked a question.
It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck.
We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle.
Yeah, LTL true crime, we going deep in the dark. Yeah, peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie, getting into minds of the wicked, no alibi. LTL true crime, unraveling the web of evil. No stone left unturned, we dive into the prime. Yeah, we digging up the dirt, bringing justice to the crime. LTL true crime, unveiling dark realities every time. Yeah, LTL true crime, we going deep in the dark. Peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie, getting into minds of the wicked, no alibi. LTL true crime, I go. We go get living the show, but then I'm not talking about it, that's so. Put the pussy in the world. No punctuation lie. No punctuation law. We better hit that. You'll be without it, die. Better do what the boats. I think they'll true crime. I'm done with dark realities every time. This is I think they'll true crime. I'm done with dark realities every time. Yeah, LTL true crime. We going deep in the dark. Yeah.